Well, welcome in everyone. Today we have Brittany sharing. Brittany, I'm not exactly sure of your full title here. Would you like to introduce yourself first?
Sure. It's Brittany Scantlin Lall. I know I keep it complicated with the hyphenated last name.
All right. Well, my name is Belinda Dunn. I am the Adult Services Librarian here at North County Regional Library located in Huntersville, with the Charlotte Mecklenburg Library. I specialize in small business help and as well as cool things like this as far as law help and things go. Shelby?
Hi, I'm Shelby Benson. I am the Director of Outreach at the Mecklenburg Bar Association. We're really lucky to have this very fruitful partnership with our friends here at the Charlotte Mecklenburg Libraries. We're glad to welcome everybody. I think this is our first presentation for 2026, so we're really excited to have Brittany join us and give us a wealth of information about estate planning. We know it's a topic that affects just about everybody, so we're really looking forward to sharing some helpful tips for you. All right, and I think we have a who have joined us, but Brittany, I think we're good for you to take it away whenever you're ready.
Awesome. Let's just get going because this, like you said, this is always a conversation that has a lot of questions and adjacent things to talk about. So I'm here for it. So this is just a 30,000 foot overview about estate planning, what we need to know so you are armed when either you walk into that attorney's office or start to have that conversation, or if you're faced with it, if a loved one is planning, maybe you have some questions to ask them. So hopefully the goal here is to demystify a little bit of estate planning. Let's see, hang on. There we go. So yes, I am an estate planning attorney here in the Charlotte area. I'm going to make a side note about that. I know we're so close to South Carolina here in Charlotte. If you do move across the border, you can take all this information, but I would recommend that you do talk to an estate planning attorney in South Carolina as well. We have close laws, but we don't have identical laws. So just kind of keep that in mind. Or if you're talking to a loved one out of state, they might have similar but not quite exactly the same laws. So just kind of, we're talking about North Carolina today. I have a mobile estate planning business, Estate Plan Van. So if you're in the South Charlotte area, you might have seen me driving around. Give me a friendly honk sometime. That's one of those businesses that popped up around COVID and ended up being a pretty convenient platform for a lot of people. And as you see here today, I'm also a speaker on estate planning awareness and education. The goal here is to make estate planning maybe more approachable for everyone, possibly even fun. We're going to learn how to take some steps today through some education and learning what we can do next. It's funny, prior to being an estate planning attorney, I was also a land use and local government attorney, and I also taught business ethics and legal studies. And in those days, when I did that, people would say, "What do you do?" And I'd say, "Oh, I'm a municipal lawyer." It'd be like crickets. No one had any follow-up questions. No one was remotely interested in what I had to say after that. But these days, when I say, "Oh, I do estate planning," inevitably someone wants to jump in and either they've just done it or they think they need to do it or their mother-in-law just did it or they know someone. So it's just, it touches all of us, like we heard in the introduction. It absolutely does. So whether it's for you or a loved one or someone you're talking with, this is really a great area of law to just get a good 30,000 foot overview on. But let's make sure we're all on the same page to start with. What is estate planning? When I'm talking about estate planning, I am talking about a comprehensive estate plan. And it includes kind of two categories of documents. Those documents that take effect when you pass, and those documents that take effect if you're living but you're incapacitated. So the first one is what happens to my assets that are in my name alone when I pass? Where do I want them to go? How am I going to get them there? And who is going to be that person that I name to help make sure that process goes as I've wished for it to? If you have minor children in your care, this is also the place where you nominate who you want to take care of them if they were minors when you passed, minors being under 18 years of age. And this other category of living documents Just as important, sometimes people stop at a will or a trust in estate planning and don't think about these other things. These other things are what happens if I'm incapacitated and can't make the next right decision for myself, but I'm living. These are your things like your financial power of attorney, your healthcare power of attorney, your advance directive. An advance directive is what some people call a living will. We'll talk about that in a little bit, but what happens if I'm at an end of life situation? How do I feel about being kept alive through artificial means? So those sorts of things. So those documents are equally as important to make sure you've wrapped up as part of your estate planning. So this is what we're talking about today. All right. Admittedly, this is a little bit better with a live audience, but we're going to do it this way as well. You can participate from your car or at home. Just think for a minute. Do you even know what percentage of Americans have a will in place? 32%, friends. That is not a large amount of Americans. And this is a very recent study. This was done back in fall of 2025, just shy of about 10,000 people. And it was 32% of people reported having a will in place. Okay, that means that approximately 70% of us do not have a will in place. The statistics for a will and then those living documents that I talked about, like a financial power of attorney, healthcare power of attorney, they are roughly similar. So we can kind of like combine it all and say it's roughly 30% of us having a plan in place, 70% of us have not done that. Okay. So again, works a little better live, but here we are. Think about if you or someone you know is immortal. Okay, I'm thinking nobody here is raising their hand. If you know someone that's immortal, I would love to have that conversation offline with you. But to our point, of the approximately 70% of us who are not planning and don't have an estate plan in place, 100% of us are mortal. That means we are going to die. We will die without having planned for what we know is inevitable. That's the heavy part here, friends. So what? Okay, that means that 100% of our 70% of non-planner mortals have chosen to have the state of North Carolina go ahead and make a plan for them. That means 100% of our 70% of non-planner mortals have given up their right to plan for what might happen in the event of their incapacity. Okay, not everyone is incapacitated. Some people just pass. And what will actually happen when they die, because we all will die. And last I checked, nobody likes giving up their right to anything. Okay, as I mentioned, the state of North Carolina and most other states, but the state of North Carolina has a plan for you. There is an entire section of statute that deals with the laws of intestate succession. Dying without a will is called dying intestate, not interstate, intestate. It means you've died without a will. A real important point here to know. You might be like, yeah, I did a will a while ago. I have a copy of it. Friends, in North Carolina, if you can't produce the original will with the ink signature on it, if you can't produce that, the clerk is going to treat that as if you didn't have a will in place. So just kind of put that as a note. If you feel like you did it at some point, maybe you know where there's a copy, but you're not sure if you can lay your hands on an original, that's a great thing to look at. Year after year, the concept of e-wills comes up in our state legislature. The idea of being able to have an electronic will rather than the actual paper copy. We're not there yet. We haven't gotten to the same everyone on the same page of what that's going to look like. So for right now, ink signatures, originals are the name of the game. Okay. So the state, and I will add what's the state going to do for you? The state's plan is going to vary depending on if you're married, if you have children, how many children you have, if you have parents that are alive, and it'll just sort of keep going up your family tree. Some people are totally fine with that. But once you get into the reads, sometimes when people learn what's going to happen, they're like, oh, no, 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 that's not what I would want to have happen at all. So just something you need to be aware of. Let's just add in this other statistic because we're hearing statistics for a minute. Less than half of us trust our federal government, and about half of us trust our state government. So, with that level of trust, I think most of us who are not planning really don't want to hand over that level of decision making to our government. Side note about this statistic, it is evergreen regardless of what party is in power. It just switches depending on sort of where your alliance is. So this kind of changes year over year, but it's just who's falling in what category. So this stays pretty stable. All right. And just to kind of hammer this home, people need to understand if I don't plan, the state's plan might not reflect what my actual wishes are. Estate planning or otherwise, the law perpetually lags behind social and technological evolution. It just does. It does not keep up with it. So these are just some examples of ways that you might need to tailor your planning, specific to you. Like if we have grandparents that are primary caregivers, if we have unmarried couples, um, people think, oh, I'm common law married. That's not a thing anymore in North Carolina. You can't be common law married. You have to be married, married. Doesn't matter if you're living full time with someone and you call them your spouse, you're not automatically married anymore. Or non-traditional couples and families. Okay. You need to make sure your wishes are
We're blocking
are
somebody, I think so.
clear as it relates to your family. Not to mention, I'm just talking about what happens if you pass, but what happens if you're incapacitated? Do you want an administrative process to figure out who's going to make your next best decisions for you, or do you want to have had a say in that? All right, if that was not enough, did you know, friends, that if you have property that you haven't planned for, nobody knows about, at some point it will drift into the North Carolina Unclaimed Property Fund. As of when I created this presentation, there's a little over 1 billion with a B dollars in the North Carolina Unclaimed Property Fund. So this is where stuff goes after a while. No one knows who it should have gone to. No one has claimed it. It's been inactive and it lands in this fund. I mean, you might as well plan for what you have. Um, it's funny on that note, I was doing one of the live kind of like call a lawyer events last year, and someone called in and I was telling them about this and advised them to look it up online and put in their name and see if there was anything in their name. And after I got off the phone, the volunteer that was next to me had overheard me and said, "Oh, hey, I heard what you just said. I just searched and I found $38 in my name." And I was like, "Oh, congratulations. I'm so happy for you." So that's real property will just move into this fund and we don't need to do that. Okay, so you get it. We're mortal, we have rights, so let's make a plan. And here, if you're not even convinced from the practicality of it, here is a nice little study I came upon. Planning can lead to a happier life. No, that is not estate planner propaganda. You might have heard of there's a project called the Legacy Project, and it's in Cornell University, where they're interviewing 80, 90, 100-year-old individuals. And one of the overarching themes that they continually talk about, how to live a fulfilling life, is to not worry as much. Control what you know and let the rest go. That is what we're doing with planning. You're doing the best you can with what you know, and then you can't control everything, but control what you can and then breathe a nice sigh of relief and know you've done what you can do. All right, you get the point. We all have the right to plan for incapacity and death. So why not exercise it? I know why you're not exercising it, because there are all these hurdles that are myths or roadblocks in your head. It's too overwhelming. I don't want to think about it. I don't have a lot of money. I don't need an estate plan. I'm not, a millionaire, a billionaire. I don't need to do this. Well, my spouse is just going to get everything, right? I don't have to do anything with that. And I don't want to spend the money on it. All things that we're going to address here. Okay, it is overwhelming. 100%. Absolutely. Doing this, when this is what I do for my living, and I will tell you, it is so much easier to walk another person through this than have to go into this headspace for yourself. It can feel incredibly overwhelming. My suggestion, though, is to come at it from a positive place. When you're going into this, think about how you would like to be remembered. What do you want people to think about when they think about you? Think about legacy. Think about how do you want to be seen? Oh, this was a provider for the family. This was a champion of animals. This person was a devoted church member. This person devoted their time to nature. Fill in the blank. That's what you're doing here. You're kind of leading a path about your legacy and you're making it very, very clear. Focus on the positive things because it's very, very easy to feel like this is sort of too much to get into. When you're getting into it, think high level. Who are the people and organizations you want to provide for? For the things that are in my name, who am I providing for with those? And who are the right people to help make that happen? Could be a spouse, could be a family member, could be a close friend, any of these things. So you're thinking kind of high level, where you want things to go, and who is the next right person to make a decision for you. And again, with the overwhelm, plan what you can for the next like 5 to 7 years. You can't see the future, but you can always update a plan as it changes. And a plan that's really close to what you wanted is going to be a lot better than no plan at all. Getting paralyzed to the point that you can't move forward and you don't make a plan. Um, that's it's going to be better to have it and update it from time to time. So take the step. I don't have a lot of assets. It doesn't matter. Okay, it does matter. Estate planning isn't only about big amounts of assets. It's about peace of mind for your loved ones by exercising that right to plan. Um, I know because I've talked to so many people about this. Sometimes it isn't the fact that you did or didn't inherit $1 million. It's that who got that really special teapot that grandma always used. And she always told me I was going to have it. And she knew it meant the most to me. And in our living healthy moments, we might not have even thought this was going to be an issue. But some of these really emotional things can come out in the process of going through a loved one's assets after they've passed, big or small. You're creating this peace of mind. And I'm pulling a quote from Brene Brown. She did not say it in relation to estate planning, but in that same vein, clarity is kindness. That's what we're doing. We're laying it out. We're saying why we're doing it. So no one has to read between the lines or guess what someone would have wanted. Nobody's debating what you wanted to have happen. And this is everything from with your stuff to what do I want to have happen at a memorial? How do I feel about funerals? I've had people get very, very detailed into this. There's some people that say, I don't want to think about memorials or anything like that. But I have had people write down detailed instructions about things like nobody wear black. Everyone bring a dog to my memorial. Everyone have a party at my memorial. This is my playlist. I recently planned for someone that it was great. It was a husband and wife, and I kind of got to this part of the planning, and the wife was like, no, thank you. I don't need to go too much deeper there. And the husband was like, oh, this is great. I can use my memorial playlist that I've started. And he was totally into it. Um, so, everyone comes at it a different way. I didn't plan for this. I heard of this. There's a woman passed too early due to cancer. She was a very avid lake goer, Lake Norman goer. And her part of her instructions were, I don't know what is going to happen exactly when I pass. So underneath my dress, I would like a bathing suit. And why don't you put a visor in with me? Because I just need to be ready just in case. Now, is that going to make it, better? No, it's still sad. It's still a really horrible time for everyone. But I will say, for the people that knew her and for the loved ones that were carrying it out, it was actually a really sweet thing. And it was a very, very nice sort of like moment of something to carry forward for her. Anyway, you understand. Um, Again, I'm going to reiterate, this isn't just about what happens when I die. This is what happens if I'm incapacitated. If you become incapacitated and can't make decisions for yourself and you haven't named who's going to do it for you, then the state has a guardianship proceeding that your loved ones are going to end up taking you through to decide who gets to make decisions for you. That might work out the way you wanted it. It might not. It is a long process. It's an onerous process. And if you can avoid it and have a say in it, you might as well and name those agents on your powers of attorney. Um, and finally, if you do take a minute, and this happens with clients all the time, if we just take a pause and like go through our assets, big class by class assets. Do I own real estate? What bank accounts do I have? Do I have any retirement accounts, any of any nature? Do I have any investment accounts? Do I carry life insurance through work or privately? What vehicles do I have? Do I own a business? Do I have any collections? If you take a minute and truly just sketch, just estimate some numbers, what I find is that people realize they have actually a little more than they think they do. And they're like, oh, that's not the number I thought I was playing with. So big or small, it is still important. Okay, my spouse just gets everything. All right. We alluded to this. Maybe. Maybe depending on your family makeup, that might be what happens, but you don't know what you don't know. No matter how good they are, even online forums sometimes can't alert you to what you're not aware of. Um, Pitfalls just to be aware of. Have you filled out beneficiary designations correctly? What is the deed to your home look like? What are the title to your vehicle? What does title to your vehicle look like? Second marriages, blended families, what have you updated? Unmarried couples, single parents. There are just a lot of different factors here that might not apply to you or might not be something that works for you. Alrighty, let's take a minute here. What a will does not control. All right, things that are jointly titled. So your bank accounts that you own jointly with rights of survivorship with someone else, that is going to automatically pass to that other person when you pass. Okay, no questions asked. Vehicles owned jointly with rights of survivorship, same thing, that's going to automatically pass to the other person. And your house, this is a nice time if you live in the Mecklenburg area to search yourself on, search up your deed online, remind yourself how it's written. Is it you individually? Is it you and a spouse? Is it you and someone else jointly with rights of survivorship? Is it you with some sort of other ownership right? That deed is going to control how your property passes. In North Carolina, we have a really interesting tenancy for married couples for primary residences. That's tenancy by the entirety. That means if you're on a deed and it indicates that you are married, referencing a spouse, that means your spouse is going to automatically own the property when you pass. And bonus, you get a little bit of creditor protection for that surviving spouse. It's a really wonderful law, and it's great. And if you have that's awesome. But it's something to keep in mind. Couples, if you are on a deed but you purchased the house before you got married, maybe time to go back and look at that deed and see what it is. Other things, assets controlled by beneficiary designation forms, like your retirement accounts, your 401ks, your 403bs, your any vehicle that's really related to something like that, your investment accounts, your life insurance, all things that you probably filled out beneficiary designations for, you probably had to at some point. How those are written are what's going to control. Okay. I'm going to jump ahead to one of your action steps, and that is find those beneficiary designations. I know a lot of us, if we're fortunate enough out of school, which doesn't happen as much anymore, to have a job that provides some sort of benefit, maybe you put a sibling on, maybe you put a parent on years ago when you started something, and now you're 20 years down the road. Did you ever update that? Did it travel with you? Did it go somewhere else? Hang on, are these all up to date? Are they what I want them to be? That's not going to be controlled by a will unless it's just blank. If it's blank, then the beneficiary designation, then it'll go through your estate. The downfall of that is that it will be subject to whatever debts that you have at your passing. It'll be subject to creditor collection if you have any. And assets properly titled in a trust that are not in your individual name, will not be controlled by a will. These are more like, hey, if I'm a blended family and a second marriage, let's just remember some things that we need to keep in mind, touch on as we're planning. As we talked about, generally, when you don't have a will, a surviving spouse splits with kids. That could be correct for you. That might not be correct for you. Again, if you don't have something that says what you want for a guardian, the court is going to decide, and that's going to be until the child's 18. Starting who's going to manage their money. In North Carolina, we divide up guardians. Guardian, you could be a guardian of the person. That's kind of the day-to-day person that's taking a child to school, tucking them in bed at night, feeding them their meals. And then a guardian of the estate, that's the person that's managing their money. That might be the same person in your head. You might say, "Yep, I know who that person is for my people," and that's going to be the same person. But it doesn't have to be. And when you don't have any of these nominations, this is all left up to the court to decide. And if you have a say in it, you probably want a say in it. Um, Most people I know, when they think about it, they don't want their 18-year-old simply getting a lump sum of money or a large amount of assets simply when they turn 18. They want some sort of controlled distribution. A common concern with second marriages and blended families I often hear is, how do I make sure my spouse is provided for and yet ensure my biological children also receive the bulk of my assets at the end of the day? That's nothing the state's plan is going to have in place for you. That's something you're going to need to do some advanced planning to make sure happens. It's very common, and we plan for it all the time. Another common situation is unmarried couples. Friends, when you are unmarried, you're just not entitled to anything. You don't have rights in this situation. Like I said, we're not in the common law marriage world anymore. So simply because you are with someone for 10 years, 50 years, however long it is, but you're unmarried, we don't automatically have rights. So just that's one of those places where you make a plan because you say what you want and you make it clear to everyone. Same thing kind of with single parents. Really need to make clear what you need. Who manages assets left to the kids? Are you comfortable with that being your ex? Or do you want that to be someone else? Do you want to say in what happens with your assets? Just one of those sort of times, hey, I might have some special planning considerations if I'm a single parent. Common enough, but something that you need to plan for. Here's a big one. I don't want to spend the money, and I feel this deeply. Let's see, when I go and take my car in and I'm told I need, 4 new tires, it galls me. It's so much money. I'm not a car person. I mean, despite the fact that I drive the van, but I'm really not a car person. So I don't have like a glow when I drive out of the car place and I've got new tires. I'm like, yeah, look at these tires. Maybe similarly not quite as exciting to do an estate plan because it's really like you're making it and you really don't want to ever have to use it anytime soon, right? I get it. It is money at the outset that is just not necessarily a fun thing to do. Nobody wants to do it. Things to keep in mind: not spending the money now could cost your estate much more money down the road by people having to figure out where things are, what you wanted, family members arguing, all of that. Money up front could take care of what could be a really complicated tangled web to untangled in the future. We kind of think of this as a gift you're giving that you never get to see received. And waiting until you need this, I know I'm speaking to some people that understand this or have seen this, it's too late. You cannot wait until you need it. I do regularly encounter the situation where someone wants to update mom's documents, dad's documents, but it's just that they don't have the capacity anymore to make decisions and know exactly what they're doing. And that's really hard. That's a tough thing. Update, plan now, and then update down the road as you can. Because when someone loses capacity, that can be a tricky situation. So I got it. I'll just do it myself. Okay, friends, I'm not going to tell you you can't do it yourself. You absolutely can. Um, you absolutely can. But I am here to just sort of flag some things you need to be aware of in the event you go down that maze on your own. I've mentioned this before. You don't know what you don't know. For example, I spoke to a client one time, and she said my dad passed a freak motorcycle accident, and he told me he had the will all set up, and I was the executor, so I was just going to take care of everything. And I came to realize he hadn't actually made a will. What he had done was make a power of attorney. Hey, great, comprehensive, but a financial power of attorney ends any sort of effectiveness when you pass. So he hadn't actually made a will. He had made a financial power of attorney. That would have been great if he was living and incapacitated, but it did no good for this daughter when he passed unexpectedly. And he absolutely, from talking to her, thought he had checked the boxes and done the right things for her, but unfortunately, he had not. Um, things, and we'll go back over this again, that you could wade into and not realize maybe you've created a little bit of a conundrum is putting minors on accounts that are joint with rights of survivorship. I'm not talking about a custodial account at a bank, but I'm talking about sort of like your regular checking account. You say, oh, well, I'm just going to put my 16-year-old on it and we'll just jointly own it with rights of survivorship. Institutions are not going to give over complete control of your bank account to a minor. They're just not. Um, so simply naming a minor child is not ensuring that they are the one they are going to get it and they're going to get it in the way you want it. Putting someone else's name on a deed. This is a very popular one because there's lots of information out there on doing that. The ways that this gets handled state to state are very different. I mentioned tenancy by the entirety in North Carolina. You go outside of North Carolina, and that is not something everywhere. So this is just also another area that you kind of get tangled up in that you need to know. When you put someone else's name on a deed with you, guess what? They also own the property. That might be a no drama situation for you, or that could end up being a bad thing for you because they own it. They don't necessarily have to do what you want with it. They're also an owner on it. By putting them on a deed, you might have inadvertently gifted them a very large asset for which they might have to pay some sort of tax on. If they have debts of their own and someone ends up looking for assets of theirs to reclaim in some sort of debt collection, now guess what one of their assets is? Your house. In North Carolina, when you have like, let's say a parent and a child on a deed, and that child is married, even if the spouse is not on the deed as well, if you go to sell that property and that child is still married, that spouse has to sign off on the sale of the property. In a wonderful world, harmonious world, that's fine and everyone cooperates. But if someone decides not to cooperate in that situation, you've created for yourself a little bit of a tangled situation that you didn't mean to when you thought you were making things easier. Um, Beneficiary designation forms, again, you could leave them blank. Leaving them blank is going to just mean it goes through your estate, which means it's going to pass through the probate process, which means it is open to debt and creditor collection in the course of closing out your estate. There could be a reason to do that, but you should just be aware of it. And leaving money to minors. I think I've gone over this. We can't have a minor named on that 401k. An administrator is not going to simply write a check to a minor. What they're going to do is go to the court and say, this is a minor, you need to appoint someone to handle their money until they're 18. Then they'll get it when they're 18. There are ways to plan around that and how to manage a distribution to a minor, but it's not by putting their name on a beneficiary designation form or a transfer on death form. If you have a loved one with special needs in your life, you need to be aware of this one too. When someone receiving government benefits receives an inheritance as a beneficiary of a will, of a trust, and suddenly their means have now gone up because they've inherited, you might have the best of intentions with that, but you might have inadvertently disqualified them from the benefits that they're receiving. So you need to plan very carefully if we're possibly dealing with someone who's receiving government benefits. And of course, like we said, second marriages is just people plan with it all the time, but you need to be aware, am I comfortable with my spouse making decisions for my biological kids and their biological kids? What's the dynamic? Do we need to kind of separate some of the distributions so everyone feels heard and seen if I were to pass? All right, so you're like, I've got it. I'm gonna figure this out. I might go visit a lawyer. I might talk to one on the phone and just kind of take my next steps. Um, Here's what you can expect for basic estate planning. A will. You should absolutely have a will in North Carolina. That's what we need. That avoids that intestate procedure where the state plans what happens. We need a durable or financial power of attorney. That's that document that says if I'm needed, who is going to make the next right financial decisions for me while I'm living but unable to make my own choices? These can be effective immediately. You can have someone ready to step in that could help you today, or they can be what's called springing, and that means they're going to only be in effect when an incapacity event has occurred for you and you are incapacitated and unable to make the next decisions. The durable term in there just refers to it's still going to remain in effect even when you're incapacitated. Healthcare power of attorney, that is what happens if I'm incapacitated and someone needs to make the next best healthcare decision for me. Do the surgery, try the procedure, etc. Advance directive, like I mentioned, this is also what some people call a living will. This is the what happens if I'm at a truly end of life situation and I can't express how I feel about being kept alive via artificial nutrition and hydration, so the use of tubes. How do I feel about that? I'm going to go ahead and make a statement of it up front, so nobody has to guess. Anyone here listening to this that's been through that, it's horrific enough if you know if someone said what they want. I mean, it's already a bad situation, but if someone has not expressed what they want and you have people with different opinions on what your loved one would like, it is a really horrific situation. Um, in North Carolina, sometimes that healthcare power of attorney and that advance directive are combined into one document. You might have one document that has both things in it, or you might have them separated out. Either is fine. If they are separated out, you just need to make sure the two don't conflict with one another. North Carolina allows us to make an advance directive in the situation if you have an irreversible or incurable condition. People think about that as like an end stage disease, like an end stage cancer. You are unconscious, you're not likely to regain consciousness. So that's sort of more of a traumatic event that your doctor said you're not going to come out of. Or you have advanced dementia. So people think about that like an end stage Alzheimer's, when you are truly at an end of life and you cannot communicate how you feel about receiving an IV with fluids to keep you alive. You get to say, follow my advance directive exactly, or you get to say, I give discretion to my healthcare agent and they get to make the best decision they can, but I'll have expressed my wishes and then they can take comfort in them and make the ultimate call of when is the right time to end the treatment. A HIPAA form is just that form that says who can call, who can request medical information about me. And beneficiary form direction. Certainly at the conclusion of your planning, certainly at the conclusion of my planning, you're going to get a series of instructions. It says, this is what your plan does. Here are the different asset classes that you have and what we need to do to make sure they all point in the same direction as your estate plan, to make sure we're clear on that. Okay. At this point, I think everyone probably has a pretty good feel of what a will does. A will directs the distribution of your assets. What property is going where, to who, and at what point is it going to go there? My art collection is going to my niece. My, grandmother's engagement ring is going to my daughter, that sort of thing. It manages the distribution of assets. When we're dealing with minors, we absolutely have the ability to decide and put some guardrails in. Do they get something right when they turn 18? Do they get access to it over a series of ages and stages? Or are we just going to keep it protected ongoingly in some sort of trust vehicle, regardless of what that is over time? How am I going to do that? Um, this involves giving gifts to family members, to loved ones, non-family members, chosen family members, charities, all things that are just tailored to who you are and what you value. A will appoints an executor, the person that's going to take your will to the courthouse. Tell the clerk this person has passed. I'm the executor. I'm going to make sure everything goes where it needs to go. And is going to nominate a guardian that's going to nominate who is going to take care of the kiddos up until they're 18 years old. You'll note that there's a difference here. Appointing an executor, nominating a guardian. It is just a nomination. You are just telling the court, if I wasn't here, here's who I strongly think would be the next best person to take care of my kiddos. But I will tell you, in North Carolina, a clerk is going to give a lot of weight to your nomination in your will. So absolutely make it clear. Also, you can say if there was someone you didn't think should have access to your children, you can absolutely spell that out as well. This is your chance to say, here is the best way I think my children should be raised if I wasn't here. So you can write who you would also think would not be an ideal candidate. Then we've talked about the living documents, that financial durable power of attorney. You need to think about who is going to be your next person and then who's a person after that. For all of these roles, it's always best to think, who is my next person that's going to help me? And then who would help if they couldn't do it? If you can, I mean, certainly if you're just thinking, and you cannot come up with a second person, okay, just nominate one person. One person's better than zero people. But if you can come up with a backup, that's totally fine. Sometimes you can appoint people to work together if you think that would be better. You can absolutely do that. Same for your healthcare power of attorney. Who's the next person to make a decision, and then who's the person after that? And we talked about what an advance directive is. How do I feel about being kept alive? And then who would have access to my healthcare, protected healthcare information? And the result is clarity. This is what we're going for. You give peace to your loved ones using the law. But do not forget, friends, we've also got a massive digital footprint in the world today. This falls in that first kind of one of those first things I said where the law sort of lags behind technology a little bit. Technology moves a bit faster than law. So there is not one uniform rule for what happens to your electronic assets. And you've got a lot of them. This is just sort of like a quick list of things that you might have, but sure you have emails, you have different forms of social media, you probably have some digital files, whether they're on your phone, your laptop, in a cloud somewhere, maybe multiple clouds. You might even have rewards points somewhere. I know I'm dealing with a lot of clients lately that have interval ownership or timeshare ownership that's dealt with in points, and how do you pass those on? Online points, if you're doing shopping, do you own cryptocurrency? That's its own class of things. You might have some ebooks. You might have gaming accounts. You might have streaming accounts. You might have dating apps. Have you thought, if you have a dating app, who would you want to have access to that app when you pass? And that goes across the board, whether you are 18 or 78. Think about who you would want to be able to see that. And if you are in business and you have business services like blogs or web hosting or LinkedIn accounts, any of those, who would you want to have access to? Alas, I cannot tell you there's one way to deal with them. What I am telling you is what you need to think about as a plan for them. Some accounts, some different online accounts allow you to go ahead and set up a legacy contact. Here's who could access my things if I pass. I can't legally tell you to share passwords because most of these sorts of assets, you've said things like, I am the only one using this account, but you do need to have a plan. How are we going to deal with these things? What do I want to have happen? And if you have poked around on the internet or just been talking to people, you've certainly come upon the topic of revocable living trusts. Some people call them revocable trusts. Some people call them living trusts. Some people just say trusts. There are a lot of different kinds of trusts. Revocable living trusts are sort of the most common one that I come across people having questions about. And here are reasons that people might use them. You might want to avoid probate. You might want to get everything into a trust, so we're just avoiding probate at all cost and keeping everything nice and easily passed through that administrative process and gets to who you want it to get to. I couldn't find a picture of a wagon with packages in it, but I imagine this as sort of like a wagon that you're pulling along behind you that you've put instructions in. And then you might have some assets in it already, or you might be pointing your assets and telling your assets through a beneficiary designation form to drop into that wagon when you pass. And then when you pass, all that happens, you're no longer pulling the wagon, but the person that you've nominated to step in as a successor trustee has gone in, picked up the wagon handle, and kept walking with it. And then plays according to the rules that you've put in that wagon and said how you want things to go. Privacy. Some people use a revocable trust for privacy purposes. Like I said, you need in North Carolina, you still need a will, and you still need a will whether or not you have a trust. That's a little bit of a misconception I've come upon lately. If you have a trust, you do still need a will. Your will is just going to be really short. It's going to say anything in my name, I mean to go into my trust when I pass. But all the same, that will is going to go to the courthouse. And if you have only a will, and it's filed, it's public record. You can go through, you can look at what people have said in their will, you can kind of comb through their business. With a revocable trust, it does not need to be filed with the court. So it does keep the process as between you and your successor trustees. Minor beneficiaries, this is a reason that I have a lot of clients that want to use them, is when you have a minor beneficiary, the ease of access to your assets is a lot quicker because, again, this is just the administration of an agreement between you and your successor trustee that you've already put in place. Their job is going and making sure that the assets get poured into the trust and it gets funded, and then the kids can have access to it. But that is different from having the process overseen by a clerk. The courts are wonderful and their clerks doing amazing work there, but there's just a lot of work there. There are so many people, there are so many cases. And if you want to move a little bit faster, ease of administration, we use a trust. And then you can tighten the screws on the rules that you put in your trust and create kind of longer term asset protection for your loved ones. While you are living, your revocable living trust is not an asset protection piece for you, but once you pass and your trust becomes irrevocable, when you've passed, then that can become asset protected for your children if you plan in the right ways. So you do not have to have a trust, but it is a tool that a lot of people get interested in and kind of want to talk through if it's for them or not. Next steps. All right. So hopefully in this whole course of things, you've begun thinking about your goals, what you want your legacy to be. Again, get in a positive state of mind when you're thinking about this, what you want to leave, how you want to be remembered. Kind of prompted you as we've gone along. This is the time to begin gathering names of people who you would think would be good helpers, names of people who you might want to be giving things to. Just start collecting that, just getting that in mind. Maybe have that conversation with either the cousin, the close friend, the sibling. Talk through it with family. Hey, how do we feel about this? Should people be working together? How to, talk about it. And then also begin gathering your existing beneficiary designation forms and other ownership documents. All those things that might actually be controlling the distribution of your assets, maybe you've forgotten about, maybe you haven't looked at in 10 years. Let's pull those out. Let's see what they say and make sure that they are congruent with whatever estate planning you get involved with. Or if for some reason you're not estate planning, they at least say what you want them to say. All righty. I think I've been trying to keep track here. And I think we are at a place where we've got about 10 minutes for any sort of questions, comments. I'm going to stop my screen share so that you know I'm a person. All right.
Let's say it looks like we had one question in the chat as we went along, but I think you might have addressed it for Hilda. I don't see any other questions in the chat here at the moment, but those might come through as people are thinking on it.
Yeah, that's totally fine. And I'm
And
gonna
I'm glad.
yeah, I was gonna say that and I can put it back up. The last slide has contact information. If you just even want just a conversation, just to follow up, or I wanted to talk about this more, absolutely fine. We can chat and I will either point you in the right direction or we'll decide if we need to work together or you need to work with someone else. And I'm happy to get you going in the right place too. Here, Shelby, I will share that one more time just in case people wanted to capture that.
And I think Belinda had some helpful information too about some
Yes.
resources that folks can use here at the library. And I'm happy to provide some additional resources in the chat as well. Belinda, I think you are on
I
mute.
am on mute. I just saw it. Okay, I think she has to unshare her screen before I can share mine. Let me see. Oh, okay, never mind. I got it. Okay. All right.
It looks like someone had a question about ladybird deeds. I don't know if you're familiar with that, Brittany.
Yeah, that is fair. That is absolutely a strategy that some people use. I would just say talk through that. I mean, that's a deed. You're going to need to talk to a real estate attorney that does deeds to prepare them, but just make sure you talk through that with someone to make sure you're clear why you're doing it. I have had clients come in and want to do a ladybird deed and then decide, oh, actually, at the end of the day, it's going to be easier to do a trust, and we're just going to put the house in the trust instead of doing a ladybird deed. So there's just some consideration. So it's certainly a planning tool. It's available, but just make sure you talk through it with whoever you're working with.
All right. Are you all ready for me to share? Okay. All right, so this is our the main page for the library, cmlibrary.org. That's where you will access this database. Um, Starting from this page, you want to go to research and learn, and then you want to search for source. And we have our limiters here on the side. Click legal and then apply filters. And you can also click another L too. Well, I guess it's not going to work right now. So legal forms is where we want to access. A card is required. So if you do not have a library card, please come in and see us. We have 21 locations here in Charlotte. So wherever you're located in your neighborhood, there should be one near and not too far. Um, all right, so this is Gale Legal Forms here. As you can see, there's a lot of different topics on here. There's several ways to use this resource as it suggests up here. So we're gonna take a look at we're gonna look at family law. So they have stuff on family law in here. So you can do anything from pull up documents on divorce. And when I talk about divorce with people, I have to express to people that this does not mean that you'll get anything. The documents that North Carolina has, you can file it for a divorce without consulting a lawyer. If you want anything, you need to consult with the lawyer if there are assets involved at all. So, um, where's the estates at? I got lost.
It's down at the bottom, I think. Will's.
Yep, bottom
Oh,
bottom
there it
right
is,
corner, I
wheels.
see a wheel.
There it is. Okay, so here go the wheels here. So you have all types of topics here, agreements, cremation, anything from living wills, lost wills. So let's take a look at last will and testament. And so this one, complex will, maximum unified credit to spouse. We're just gonna click on that. And so it'll generate in a Word document that you can edit yourself. So this is what it looks like. I always suggest to people if you need something quick, this is what you use. If not, please consult a lawyer. Even still, you still have to take it to a lawyer. You have to get it notarized. It does not mean that it is valid. Just because he printed it off and he wrote some things on it, has to be notarized. But always take it to a lawyer and get them to review it. It just might save you just a little bit of time, maybe a little bit of money. I don't know, Brittany, you can probably I don't know if it's really gonna save them much money, but it'll save them some time, I'm sure.
Yeah, I mean, I will say I will always I have a lot of scenarios where people have done their own and they just want to like have another set of eyes on it. And usually when I
Yeah.
do that, I'm not going to speak for all estate planning attorneys. Everyone does stuff differently.
Hmm.
But sometimes if people are just like, what did I write? Is it okay? Can I get like a summary of it? I would just do like a flat fee to look at it and kind of give them a summary. And it might be, hey, that's great, or it might be, okay, we'll apply that flat fee and you want me to just, do it in different terms and we'll keep moving from there. But yeah,
Hmm.
that did remind me though, Belinda, I have run into scenarios where again, someone thinks they've written out all their wishes and they signed it and they had it notarized, but in North Carolina, you also need two witnesses. And so the will wasn't actually complete. And so it was treated like they didn't have a will at all. Again, that
Right.
you don't know what you don't know. Like the possibilities are endless. So
Hmm.
can't say that you can't create something great. I'm gonna play in this little area. I didn't even know about this until today. This is awesome.
Yeah, so I found out, well, I've been working here for 2 years now. So I found out about it when a gentleman came in and he was a contractor and he was writing a contract, and my library branch manager was like, "Oh no, we had this great resource," because she dibbled and dabbled in the business part of our libraries. So she knew about it, and that's how I found out about it. So I've been
Yeah, that's
like doing
interesting.
programs on this.
Yeah.
Um, so this is great resource for anything that you might need. But like Brittany said, make sure you know the ins and outs of it before you go through with it. So
It doesn't
yes.
mean that it's wrong. Just make sure you
Yeah.
know what you're doing.
Yeah. And also these are all reviewed by lawyers as well. North Carolina lawyers. So or documents that have been written by lawyers. So yeah. You guys can play around in it and see what you can find in here, what could be helpful to you. Um, and that's all.
And it looks like
Oh,
one of our
Hilda.
guests had a question as well. I don't know, Hilda, if you feel comfortable typing that in the chat, we're happy to share that and address that. I also wanted to share a couple of other resources. Here at the Mecklenburg Bar Association, we do offer a lawyer referral service. If you feel like you are ready to take that step and get connected with an attorney, we can assist you with that. We also provide a list of other local and statewide resources. If you're looking for something that maybe we don't cover here locally at the Mecklenburg Bar, but maybe the state bar does, we can get you pointed in the right direction as best as we can, hopefully. But I know Brittany covered a ton of helpful information, and we definitely advise if you have more specific questions, we definitely advise contacting an attorney to get some information and resources specific to what you need. And lawyers are a wealth of great information. And I can't tell if Hilda was typing a question in the chat or not, but we have a moment if anybody else has any last minute questions that may have popped into their minds before we adjourn for the day. Okay, and not seeing anything, just want to let everybody know we have recorded today's presentation. So if you find that you do need to come back and take a look at some of the information that was displayed on the screen, we'll hopefully have that posted on our website at the bar. And I think the library will have that information as well to direct if folks need to come back and take a look at it again. And it looks like Hilda was wanting to know if there's a list of attorneys who do power of attorney or healthcare power of attorney. We don't necessarily maintain a list, but I know if you need a referral to an attorney, we can certainly help you with that. And I know Brittany probably knows a lot of folks who can do that if that's not something she's able to cover, at a given time. But
No,
hopefully,
100% Shelby. Any estate planning attorney, anyone that says they do estate planning will be able to do all of those kind of living documents, Hilda, that you mentioned. That would be part of anything. So you can say, hey, I don't need a will, but I need these other documents. Super important.
awesome. Well, I think that pretty much wraps it up for today. Thank you, Belinda, and thank you, Brittany, for giving us this platform and sharing your wealth of knowledge with us.
Thanks, guys.